Made, please.
Now, which is the judgment you want us to see?
Lord, I was on Chennaiya, my lord, which is volume 5, my lord, 5th bookmark.
Yes, you got it. The theme is the same, actually, that they say that subclassification, which is permitted in Indrasani for OBCs, is not permissible for SCs because they say it's one homogeneous class.
That's right.
And therefore, once Parliament has designated certain castes or tribes or races as scheduled castes, you cannot further subgroup, subclassify. They use that expression, right? Subdivide, subclassify, or subgroup. That's the theory, really.
One is that.
And your contention is that Parliament's power to designate is very different from the state's power to implement reservations under 16.4. Right. And they have not then, therefore, had due regard to the ambit of Article 16.4. I think that is your submission.
That's the issue of identification, and this is the issue of implementation.
Implementation.
That's right.
They are not considered the interplay between 16.4
That's right.
and 341.
None at all. In fact, argued by Lord Mr. Venugopal, but not considered at all.
So, Article 341 is all about
identification.
About identification.
Stroke inclusion and exclusion of caste.
Inclusion, stroke exclusion.
While 16.4 is conferring of benefits. On those who are not adequately represented in services.
Which para were you on?
Lord, I was on 26, Lord. I just read 26
right.
before
then,
they frame the second
31
question.
also. 31 says subclassification is beyond legislative competence under entry 41 of list 2 and entry 25 of list 3. Then para 38, they say subclassification which is permitted in Indrasani for OBCs is not permissible for SCs who form one class. That's para 38.
Indrasani does not say so. I'll come to that.
We'll go directly thereafter to Indrasani because and then
that's right, Lord, because
in para 39 and 41 they say there's so the whole theme is this is one homogeneous group you cannot.
Yes, the second question which they frame in 27. Mulad have
yes.
seen that?
Yes.
Which is on judicial on legislative competence.
Competence, yes, and they answer that in para 31.
That's right.
798.
That's right. Without examining 16 though. If your lordship would have, yes, 31, my lord. Last 10 lines are relevant. It is the prerogative of the concerned state, my lord Sahib. Bottom of page 794.
Plus it me.
Yes. That's right. May I, my lord? It is the prerogative of the state concerned, if it so desires, with an object of providing opportunity of advancement in the society to certain backward classes, which includes the scheduled caste, to reserve certain seats in educational institutions under 15.4 and in public services of the state under 16.4. That part of its constitutional obligation as stated has already been fulfilled by the state. Lord, now, this is a very interesting part, Lord. They call this a one-time exercise, which I could not, Lord, conceive how, but they say once you've provided reservation, you've done what you had to do. So if I read it further, Mulad, having done so, it is not open to the state to subclassify a class already recognized by the Constitution and allot a portion of the already reserved quota amongst the state-created subclass within the list of scheduled castes. From the discussion herein above, it is clear that primary object of the impugned enactment is to create groups of subcastes in the list of scheduled castes applicable to the state, and in our opinion, apportionment of reservation is only secondary and consequential. So they say the primary objective is creating a subclass, while
totally the state may also feel that, look, backward classes as a whole are represented in the state adequately, but within the component of backward classes, there are some communities who have no representation at all. And therefore, that skewed distribution of benefits has to be corrected.
And Lord, it is not synonymous. It is not synonymous that every backward class would be a scheduled caste.
Right.
Can't be.
Some of them may be socially and educationally backward.
Yes.
Classes. Some of them may be socially and educationally backward.
Yes.
Classes.
So from amongst the backward classes, those which in your opinion you want to confer the benefit on. It's as simple as that.
What they seem to suggest is, if you are giving reservations to scheduled castes and scheduled tribes, you must take them as one composite whole.
That's right. That's right.
That's what the
that seems to be
the logic of the judgment.
That's
the entirety of the judgment is this value.
That once they've been included in the list,
then
you
either
cannot
take it or leave it as it is.
Yes, either
you
take the whole.
Decide not to give reservations at all. But if you give, you must give to everybody.
To everyone in equal proportion. That seems to be the intent.
Not
that
even
you
equal,
cannot,
not equal proportion.
No, they say you cannot apportion reservation.
That is, everybody must have a bite at the entirety of
the issue. It should be either 100% or 0.
It will go among, as per merit among that all the categories.
I bow, my lord. That is it. That is it. Then, my lord, they say whatever be the object of this subclassification and apportionment of reservation, we think, now, my lord, this is where the, my lord, interpretation of only 41 and 25 comes. My lord may take note. We think that the state cannot claim legislative power to make a law dividing the scheduled caste list of the state by tracing its legislative competence to entry 41 of list 2 or entry 25 of list 3. Therefore, we are of the opinion that in pith and substance, the enactment is not a law governing the field of education or the field of state public services. Here, 16.4 should have found its part. They say that power is being traced only to entries.
I think we've built enough
kind of got it.
Now let's go straight to Indra Sani, I think, because...
My lord, your lordships have seen question 3, my lord, para 32 and 33.
32 and 33.
32, they frame the next
question. They follow Trilokinath Khosa, that micro-classifications are not
Yes, there they consider a very important issue, that is it violative of 14? They say that whether it would stand the test of Article 14, then, my lord, considering Khosa's judgment.
There actually, Khosa, if you see page 416, what happened was, Classitum B.
That's right.
If in this case the government had prescribed that only those degree holders who had secured over 70% marks could become chief engineers, and those with 60% alone would be eligible be SEs, or that foreign degrees would be preferred, we would have unnecessarily avoided. I think there what happened was that they were going by the birthmarks.
That's right.
And the argument of the finding of our court is, once you enter service, whether you are a direct recruit, whether you are a diploma holder or a degree holder, once you enter service, then your birthmarks are erased.
Yes.
Then you become a member of service.
You will be governed by the rules under 309.
Yes.
If you are a DSP, for promotion to SP, it doesn't matter how you came.
Right.
You have to compete with the others and get through your quota. If there is for direct recruitment or promotion, it will govern you. Your lordships are absolutely right. My lord, they answer this, if your lordship would only have one line. The third question in para 37. We have already held that the members of scheduled caste form a class by themselves, and any further classification would be impermissible while applying the principle of reservation. Then, my lord, Indra Sani's finding comes in para 38, my lord, on behalf of the respondents. My lord, have it?
That we need not.
I'll go to Indra Sani.
Indra Sani.
I will show that Indra Sani never decided that in scheduled caste subclassification should not be done. Then more backwardness, end of para 41.
The thing is, we may read only one sentence there, classitum D, because that very judgment itself has specifically held that subdivision of other backward classes is not applicable to scheduled castes and scheduled tribes.
It has not. That is what I will show.
That
is what I'll show.
Just see
yes. Yes. For other purposes, it has deliberated, but for this purpose, it has never held it. Para 41, your lordships have seen, Muller.
Class as a whole.
That's right. With last 5 lines, they say that it is difficult to
leave it there. I think it's the same now.
I think
same
so.
Thing.
Justice Sema's judgment is on the same lines, my lord, than Justice Sinha's judgment concurring.
Mr. Advocate General, as Mr. Shankaran said in the morning, the reference order of penned by Justice Arun Mishra.
That's right.
Contains now an elaborate extraction of all the judgments in Indra Sani. So maybe we can go directly to the reference orders. We'll find everything at one place.
Everything would be there. Yes.
We don't flip pages then.
Where, my lord, in Indra Sani, it was a judgment, my lord, where Justice B.P. Jeevan Reddy is given the majority opinion. So that majority opinion, my lord, on behalf of him and 4 other judges, my lord, that we'll just need to see the gist of it as to what exactly have they had.
All right.
So then, my lord, I'll skip this judgment. Your lordships may have a look at it.
Dealt with the judge. Where is Indra Sani? Do you want to go?
Yes, my lord, Indra Sani is a part of this compilation.
Arun Mishra's judgment, whatever.
The original.
All right. What volume 5 page?
My lord, it starts at page 190, PDF page 194, my lord. 194. Let me just say at the outset, my lord, the exceptions which they talk of are only on 2 issues. One is on presumption of backwardness, which they opine on, and then creamy layer. These 2, your lordships may note, they do not opine on subclassification. We can come to, my lord, page 688, PDF 692, my lord.
Yes.
My lord, para 780, my lord. Identification of backward class of citizens.
Which page is that?
My lord, this is Placentum E, page 692 PDF. Internal page 715 of the judgment in SEC, my lord.
Yes.
Para starts with, now we may turn.
Yes.
Now we may turn to the identification of backward class of citizens. How do you go about it? Where do you begin? Is the method to vary from state to state, region to region, from rural to urban? What do you do in case of religions where caste system is not prevailing? What about other classes, groups and communities which do not wear the label of caste? Are the people living adjacent to ceasefire line in Jammu and Kashmir or hilly or inaccessible regions to be surveyed and identified as backward classes for the purpose of Article 16(4). And so on and so forth are many questions asked of us. We shall answer them, but our answers will necessarily deal with generalities of the situation and not with problems or issues of peripheral nature, which are peculiar to the particular state, region, or district. Each and every situation cannot be visualized and answered. That we must leave to the appropriate authorities appointed to identify. We can only lay down general guidelines. Then 781, at the outset, we may state that for the purposes of this discussion, now for the purposes of identification, we keep aside the scheduled tribes and scheduled castes, bracket, since they are admittedly included within the backward classes, bracket close, except to remark that backward classes contemplated by 16(4) do comprise some castes, for it cannot be denied that scheduled castes include quite a few castes. So for the purposes of identification, they keep aside scheduled caste, saying that there is a presumption of backwardness with the scheduled caste. We are not going into it. Then, my lord, para 782 would be slightly relevant. Coming to the question of identification, the fact remains that one has to begin somewhere with some group, class, or section. There is no set or recognized method. There is no law or other statutory instrument prescribing the methodology. The ultimate idea is to survey the entire populace. If so, one can well begin with castes which represent explicit identifiable social classes, oblique groupings, more particularly when 16(4) seeks to ameliorate social backwardness. What is unconstitutional with it, more so when caste, occupation, poverty, and social backwardness are so closely intertwined in our society, individual surveys out of the question, since Article 16(4) speaks of class protection and not individual protection. This does not mean that one can wind up the process of identification with the castes. Besides castes, whether found amongst Hindus or others, there may be other communities, groups, and classes and denominations which may qualify as backward class of citizens. So, my lord, they have pretty much carved out, my lord, then the religious denominations like Muslims, Sikhs, who do not follow the caste system, and that, my lord, if your lordship would have seen in the order issued by the president, is an exception under clause 3, that this will not apply to Sikhs, Muslims. I had shown that to your lordship, my lord, from the order. Now, the second exception, my lord, is just below in para 792, my lord. It starts from, my lord, running page 695, para 790, PDF 699, my lord.
Paragraph 792.
Para 790.
Zero. Okay.
Means test and creamy layer. That is the heading of the, my lord, discussion. Subclause D. Means test in this discussion, my lords have it, signifies imposition of an income limit for the purpose of excluding persons from backward class whose income is above the said limit. This submission is very often referred to as the creamy layer argument. Petitioners submit that some members of the designated backward classes are highly advanced socially as well as economically and educationally. So, my lord, they are talking about what is the creamy layer principle, and in 792 on page 697, I'll read, my lord, the umbilical cord argument, my lord. In our opinion, it is not a question of permissibility or desirability of such test, but one of proper and more appropriate identification of a class, a backward class. The very concept of a class denotes a number of persons having certain common traits which distinguish them from others, in a backward class under clause 4 of Article 16, if the connecting link is the social backwardness, it should broadly be the same in a given class. If some of the members are far too advanced socially, which in the context necessarily means economically and may also mean educationally, then the connecting thread between them and the remaining class snaps. The connecting thread between, they would be misfits in the class. After excluding them alone, would the class be a compact class? In fact, such excluding them alone, such exclusion benefits the truly backward. Difficulty, however, lies in drawing the line. How and where to draw the line? For while drawing the line, it should be ensured that it does not result in taking away with one hand what it gives by the other. The basis of exclusion should not be merely economic unless, of course, the economic advancement is so high that it necessarily means social advancement. Let us illustrate the point. A member of backward class, say a member of a carpenter caste, goes to Middle East and works there as a carpenter. If you take his annual income in rupees, it would be fairly high from the Indian standard. Is he to be excluded from the backward class? Are his children in India to be deprived of the benefit of 16.4? Situation may, however, be different. If he rises so high economically as to become, say, a factory owner himself, in such a situation, his social status also rises. He himself would be in a position to provide employment to others. So, my lord, they are going on a very subjective satisfaction of at which stage the cord between backwardness and the individual breaks. Now, my lord, I'll straight away go to the last 10 lines of this paragraph, where the individual, my lord, argument ends. It starts with, it is then argued for the respondent. Presentum B, my lord, on page 698. May I, my lord? It is then argued. It is then argued for the respondents that one swallow does not make the summer, and that merely because a few members of the caste or class become socially advanced, the class or caste as such does not cease to be backward. It is pointed out that clause 4 of Article 16 aims at group backwardness and not individual backwardness. While we agree that socially advanced members will make a class a truly backward class and would more appropriately serve the purpose and object of clause 4, this discussion, let me kindly note this discussion is confined to other backward classes only and has no relevance in the case of scheduled tribes and scheduled castes. So this discussion is on creamy layer, whether the individual income or the income of the class as a whole, and the parameters and factors which would define as to whether the cord and the thread between the class and the individual and its backwardness has snapped or not. So these are the only two parameters where they exclude the discussion on scheduled castes. Otherwise, Indra Sani nowhere excludes scheduled castes for the purposes of subclassification. So, my lord, in fact, if your lordship would see on subclassification, they positively, my lord, if your lordship would come straight away to 801, my lord, the question number 5, it is answered on page 702, PDF 706, my lord. Where the question is framed whether backward classes can be further divided into backward and more backward categories. My lords have it?
Yes.
And this backward, my lord, includes SC/ST, because they say in Balaji it was held that subclassification made by order between backward classes and more backward classes does not appear to be justified under Article 15(4). Article 15(4) authorizes special provisions being made for the really backward classes. In introducing two categories of backward classes, what the impugned order in substance purports to do is to devise measures for the benefit of all the classes of citizens who are less advanced compared to the most advanced classes in the state. And that, in our opinion, is not the scope of 15(4). The result of method adopted by the impugned order is that nearly 90% of the population of the state is treated as backward, and that illustrates how the order in fact divides the population of the state into most advanced and the rest, and puts latter into two categories of backward and more backward. The classification of the two categories therefore is not warranted by Article 15(4). This is quote from Balaji. Then they hold the correctness of this holding is questioned before us by the counsel for the respondents. It is submitted that in principle there is no justification for the said holding. It is submitted that even among backward classes, there are some who are more backward than the others, and that the backwardness is not and cannot be uniform throughout the country, nor even within the state. In support of this contention, the respondents rely upon observation of Chinnappa Reddy J. in Vasant Kumar, where the learned judge said, "We do not see why on principle there cannot be classification into backward classes and more backward classes, if both classes are not merely a little behind, but far behind the most advanced classes. In fact, such a classification would be necessarily help the more backward classes. Otherwise, those of the backward classes who might be a little more advanced than the more backward classes might walk away with all the seats." Then in para 802, they say, "We are of the opinion that there is no constitutional or legal bar." This was a specific question which fell from your lordships. "To the state categorizing the backward classes as backward and more backward. We are not saying that it ought to be done. We are concerned with the question, if the state makes such categorization, whether it would be invalid. We think not." Then they give the example of Mandal Commission, which may not be so relevant, because here they are comparing two castes. Like in Andhra Pradesh, they are comparing goldsmiths and vades, who are stone cutters, to be a part of the backward class, but goldsmiths will always be more affluent than the stone cutters. So there, if a distinguishing factor is made between both of these, there is a rationale which is supported. Basically, the issue is that that exercise, as and when done, has to be taken to be whether it is done with the object sought to be achieved in mind, whether it is a reasonable classification or not. Now 803, my lords, may I have. There is another way of looking at this issue. Article 16(4) recognizes only one class, which backward class of citizens. It does not speak separately of scheduled castes and scheduled tribes, as does Article 15(4). Even so, it is beyond controversy that scheduled castes and scheduled tribes are also included in the expression backward class of citizens, and that separate reservations can be provided in their favor. It is well accepted phenomena throughout the country. What is the logic behind it? It is that if scheduled castes and scheduled tribes and other backward classes are lumped together, OBCs will take away all the vacancies, leaving scheduled castes and scheduled tribes high and dry. The same logic also warrants categorization as between the more backward and backward. We do not mean to say, we may reiterate, that this should be done.
There's a little confusion over here. Does that really apply to a subclassification of the scheduled castes and tribes, or is it really referring to only the subclassification of the OBCs, other than the...
My submission would be both. Because as your
I
lordship
don't know
correctly
actually
said,
whether that may not be a correct reading of Indira Sani actually.
my lords in fact said that what is the logic? If you use,
The reservation of OBC is only for consideration. The issue was with regard to reservation of OBCs.
Therefore,
That's
they
right.
said right up front that we are leaving aside the issue of SCs and STs. Yeah.
they leave that aside only on two issues, my lord, creamy layer and identification of backwardness. When they discuss backward within the backward, they do not say we are not talking about scheduled castes.
It appears that that whole discussion in the context of the socially and educationally backward classes, the OBCs really.
My lord, whether or not it's a positive mandate, I leave it to your lordships to decide, because this judgment would most certainly be binding upon all of us. The only thing is there is no bar. They clearly and
That's a
categorically
separate
say,
argument altogether. But to say that this expressly recognizes that there can be a subclassification among scheduled castes may not be, that was not the issue really that they dealt with.
not really, but it recognizes the logic. If there is a gap between the disadvantaged and the most disadvantaged, it's a reason enough for classification. That is a rational criteria. That's what Indira Sani holds, that backward and more backward is a rational criteria.
And it is permissible in law.
It's permissible in law. Also, nothing in law bars it. Nothing in law prohibits it. So if the state, that is what I said in the beginning, there's no mandate to do it. But if the state chooses to do it, there's nothing against it.
The question is already answered here.
That's right.
What remains?
That's right.
End of the matter. 9 judges have decided.
Yeah, it's binding on us.
Then, my lord, we can straight away come to Nagaraj, my lord, or Thomas. Because that is, my lord, a judgment which is very clear and categoric, and an emphatic reiteration of the principle. This is also, my lord, in volume 5.
1336. Yep, 133.
PDF.
1336.
That is Nagaraj. No, Thomas. Page 23, my lord.
Page 27. Thomas.
Yes. PDF page 27.
Of the same volume.
That's right.
This is
Now, this was a 7-judge bench which was considering.
No, 20. That is Thomas.
Thomas.
Yes, Thomas. Yes, 1976 to SEC 7.
You want to go to
Not
Nagaraj?
just a couple of paragraphs which are relevant, because otherwise, it reiterates the issue. Because it talks specifically of 16.1 and 16.4 interplay, my lord. My lord, may just come straight away to para 24 to 28, my lord. Para 24 is on page.
Start from
High Court here is decided only on the basis non-suited you or really held against you only on the basis of Chinaya.
Quite right.
So if we come to the conclusion, of course, to hear the other side, that Chinaya is wrongly decided, this will have to go to the High Court for any other challenges, right? Any other challenges which are there to the statute. Otherwise, we will be deciding issues like adequate representation, whatever other challenges there are.
But what I can also suggest is that once your lordship set aside that judgment on the basis that Chennai itself
We
has
can
been
send
set
it to
aside
3 judges.
and leave the question of law open, my lord. If somebody challenges in a flesh litigation, we will deal with it.
But what were the challenges there before the High Court?
Primarily this, my lord, that there's a 5-judge bench
Other than that,
already
there was
there.
no ground.
So no fresh grounds were taken.
No
to
ground for
challenge.
judicial review.
The grounds were same which were otherwise reiterated in Chennai.
The original petitioners before the High Court are represented here.
Yes, yes.
So we'll see what is the nature of their challenge.
Yes,
If
yes.
Chinaya was the fundamental
We can-
basis of the petition, then we can conclude it here, one
Yes.
way or the other after hearing.
That's what I'm saying.
And then if somebody else wants to challenge it, file a petition there. Why should we?
Moroj may grant them the liberty if any additional issues arise other than Chennai. I'm sure, my lord, there's no bar in challenging them because that would be a fresh challenge.
Unless they say they have raised other valid challenges which
For
were
which-
not adjudicated, then we have to restore the petition there.
For which they would want to revive their petition. Yes, Modi. That's right.
Because one thing is clear, the High Court has gone only
Only
on
on that
Chinaya.
issue.
That's right.
The other way is that we restore it to a 2-judge bench. 2-judge bench will decide all the other questions, but they lose the right. Whoever, one person loses the right of appeal then.
Go back to the
High Court.
There was no challenge with regard to quantifiable data and all that.
No, my lord, not to my knowledge, unless they.
My lord, there can't be because in Punjab, scheduled caste are 38%, my lord, and the reservation is only 25%. So there can't be quantifiable data to that extent, my lord.
Why?
That is in the statute, my lord. 25% in direct recruitment.
No, but there
And-
could be at least, look, there will be data at 2 levels. One, are the scheduled castes as a group in Punjab adequately represented in the services of the state? That's one. 2, within the group of scheduled castes, is there, not proportionate, but is there a fair representation to the Mazhabi Sikhs and the Balmikis? Yes, government may have data on that. They would have collected data.
My lord, if
Obviously,
the
without that, they won't have come up with this
population correlation
legislation.
is there, that has to be 38%, my lord.
27 departments. Since some of them.
They means who?
The Mazhabis and
Right.
Some of them were in some departments, not a single person. Since the time the department was created, we put that department.
And what is the population ratio
39%.
amongst the scheduled
Yes,
caste?
yes,
Amongst the scheduled caste?
yes,
They constitute 39%.
yes. And yet their representation
39%.
is very, very minuscule. And the posts they occupy are of scavengers.
And the,
In
what is the
government
total?
municipalities, that's all.
What is the total representation of scheduled castes in Punjab?
25% is the limit, Millets. 25%.
38%.
What is the total population?
About
38%.
33%.
38%, my lord. There is no scheduled tribes there,
About
my lord.
33%.
So all are clubbed
33%.
together as scheduled caste,
And
38%.
the Mazhabi Sikhs and the Balmikis constitute about
39% of that.
39% of 33%.
And Millets, although there are 39 castes mentioned, but I've given that data, Millets, from government records. Some of these castes are only Millets 30 people, 70 people, 100 people, 200. So although these are 2 castes, but they represent 39%. And on the other side, Millets, 2 or 3 castes represent Millets a much larger number, represent about 43% people, but they are occupying 81% of the posts. They are the main people who are left out, whom the other side represents. So I will give that data. We'll place that.
We need not go into that question.
Look,
There is a quantifiable data.
actually, this doesn't arise. We are dealing with, it's a bench of 7 judges. We are dealing with the validity of the decision, the correctness of the decision
I
in
was-
Chinaya.
That's what I was submitting, my lord.
We will not go beyond that.
Ek
There's a
minute,
valid
my lord.
reason why
on behalf of the state.
And Mr. Swarup, Mr. Manu Swarup, we shouldn't be going into things which are not argued
That's
before
why
the
I
High
said
Court.
numericals.
We
There
should
is
inform
one-
the subject matter, the reference by 3, 5.
Only out of curiosity, we asked.
Yeah, we just generally we.
Yes, your lordship, may kindly consider.
Please rest assured, we'll not rest our decision on that at all.
Lord, I'll just ventilate one indication to your lordship, Lord. There's a reason why the state did not go into the empirical. The Lord Advocate General said twice that I'm not going into that for the reason that other people may have different data as they are monitoring. But the state data is a 2020 data of the year 2020. Their first notification came, as your lordships observed, in 1975.
Yes.
Their act came in 2006. They put on record data of 2020. Again, unverified, although there's a commission, constitutional
That
commission
will have to
now.
be argued at the appropriate.
Yes.
What data was there when you passed the act?
Exactly, my lord.
Therefore, that will impact upon the reservations for that period between the act and 2020 when
I
they.
would therefore submit, my lord,
Okay.
advisedly, on behalf of the state,
They're not going into that.
My lord, one of the arguments which we would address also here, that the concept of creamy layer has no applicability here for the simple reason, the difference between the scheduled caste and the downtrodden scheduled caste is not much. The creamy, they are not far ahead than end. One is earning little, one is earning 10 rupees, other is earning 5 rupees. So whole
I
proposition
don't
is
think
there,
that
it has
is,
a fallacy.
that has not been accepted in
which the
Journal.
state is projecting it.
Justice Nariman's
That-
judgment in Journal specifically doesn't argued.
So
In
that-
fact, the argument before that constitution bench was the concept of creamy layer has no application to the scheduled caste and scheduled tribe. And that has been rejected by, that is not in
That
question
is a
before us.
general proposition, but when we come to the factual aspect, when we see what the scheduled caste is earning and what the downtrodden scheduled caste is earning, your lordship will say that they are not far ahead. They have just
We
brought.
can't decide it on a priori basis like that.
That's your, that we would be arguing and supported by that under what circumstances the, yeah, that's all.
Mr. Advocate General, now what more? What next now?
Please, my lord. Well, I was in para 24, my lord, of Thomas,
Thomas, yes.
page 45, PDF 49. They're just short paragraphs, my lord. I'll quickly go through them. Discrimination is the essence, my lord Sahib.
Yes.
This is Justice Ray's, my lord, opinion. Discrimination is the essence of classification. Equality is violated if it rests on unreasonable basis. The concept of equality has an inherent limitation arising from the very nature of constitutional guarantee. Those who are similarly circumstanced are entitled to an equal treatment. Equality is amongst equals. Classification is, therefore, to be founded on substantial differences which distinguish persons grouped together from those left out of the groups, and such differential attributes must bear a just and rational relation to the object sought to be achieved. So, my lord, further in para 31 on page 47, PDF 51, my lord. Here also they talk of equality, my lord, amongst equals. They say the rule of parity is the equal treatment of equals in equal circumstances. The rule of differentiation is enacting laws differentiating between different persons or things in different circumstances. The circumstances which govern one set of persons or objects may not necessarily be the same as those governing another set of persons or objects, so that the question of unequal treatment does not really arise between persons governed by different.
To that,
it's
Mr.
not
It's not
necessary,
settled.
actually.
Equal treatments to unequals.
That's right. Well, that's settled law. Need not much, my lord, labor on it. So they will also come to para 44, my lord. About preference, my lord. PDF 54, our constitution. Our constitution aims at equality of status and opportunity for all citizens, including those who are socially, economically, and educationally backward. The claims of members of backward classes require adequate representation in legislative and executive bodies. If members of scheduled castes and tribes who are said by this court to be backward classes can maintain minimum necessary requirement of administrative efficiency, not only representation, but also preference may be given to them to enforce equality and to eliminate inequality. Article 15.4 and 16.4 bring out the position of backward class to merit equality. Special provisions are to be made for advancement of backward classes and reservations of appointment and post for them to secure adequate representation. These provisions will bring out the content of equality guaranteed by Article 14, 15.1 and 16.1. The basic concept of equality is equality of opportunity for appointment, preferential treatment for members of backward classes, with due regard to administrative efficiency alone can mean equality of opportunity for all citizens. Equality under Article 16 could not have a different context from equality under Article 14. Equality of opportunity for unequals can only mean aggravation of inequality. Equality of opportunity admits discrimination with reason and prohibits discrimination without reason. Discrimination with reason means rational classification for differential treatment having nexus to the constitutionally permissible object. Preferential representation for backward classes and services with due regard to administrative efficiency is permissible object, and backward classes are a rational classification recognized by Constitution. Therefore, differential treatment and standards of selection are within the scope of equality. Basically, the judgment proceeds on this standard that differentiation for the purposes of achieving the constitutional objective is permissible, which I am citing, my lord, to basically support my argument that if within the class...
Unequal treatment to unequals.
Yes. So if there are unequals even within the backward classes...
To bring them equal.
That's right. Eventually, my lord, if the government is holding the hands of people who are socially and economically backward, there can absolutely be no adversarial claim of that very class holding the hand of people who are further downtrodden. Basically, with the eventual idea of bringing everybody, if not equal, but adequately represented. That is the basic substance, my lord. Then, my lord, the next judgment, we can come straight away to my lord Nagaraj. PDF 1336, my lord. Pagination 1332.
One?
1336, my lord, PDF. Here, my lord, the subclassification was discussed and upheld pertaining specifically to scheduled castes and scheduled tribes, my lord. The main judgment Justice Kapadia's judgment. Yes. My lord, may kindly have page 1398 straight away, my lord. PDF.
Page?
1398 PDF, my lord. Here, my lord, Indra Sani, as your lordship, my lord, wanting to clarify, that is discussed as to on what purposes and what is the further interpretation given. May I, my lord?
Yes.
In Indra Sani, the equality which was protected by the rule of 50% was by balancing the rights of general category vis-a-vis the rights of BCs and block consisting of OBCs, SCs and STs. On the other hand, in the present case, the question which we are required to answer is whether within the egalitarian equality indicated by Article 16.4, the subclassification in favor of SCs and STs is a principle constitutionally valid. So this is specifically framed as a question. Article 16.4a is inspired by the observations in Indra Sani by the paras 802 and 803, in which this court has unequivocally observed that in order to avoid lumping of OBCs, SCs and STs, which would make OBCs take away all the vacancies, leaving SCs and STs high and dry, the state concerned was entitled to categorize and subclassify SCs and STs on one hand vis-a-vis OBCs on the other hand, my lord, then 802 and 803 are reproduced. Then 115, my lords, may have. Therefore, while judging the width and ambit of 16.4a, we must ascertain whether sub-classification is permissible under the Constitution. The sub-classification between OBCs on one hand and SCs and STs on the other is held to be constitutionally permissible in Indira Sani. In the said judgment, it has been held that state could make such sub-classification with SCs and STs vis-a-vis OBCs. It refers to sub-classification within the egalitarian equality, Vide para 802 and 803. Therefore, Article 16.4a follows the line suggested by this court in Indira Sani. In Indira Sani, on the other hand, Vide para 829, this court has struck a balance between formal equality and egalitarian equality by laying down the rule of 50% ceiling limit for entire BCs as a class apart vis-a-vis GC. Therefore, in our view, equality as a concept is retained even under Article 16.4a, which is carved out of Article 16.4. As stated above, Article 14 enables classification. A classification must be founded on intelligible differentia, which distinguishes those who are grouped together from the others. The differentia must have a rational relation to the object sought to be achieved by law under challenge. In Indira Sani, an opinion was expressed by this court by day 802 that there is no constitutional or legal bar to making of classification. Under 16.4b is also an enabling provision. It seeks to make classification on the basis of differentia between current vacancies and carry forward vacancies. In case of Article 16.4b, we must keep in mind that following the judgment in RK Sabharwal, the concept of post-based roster is introduced. Consequently, specific slots for OBCs, SCs, and STs, as well as GC, have to be maintained in the roster. Well, then say, therefore, by article, well, 2 lines below, 16.4b, a classification is made between current vacancies on one hand and carry forward backlog vacancies on the other. Article 16.4b is a direct consequence of the judgment of this court in RK Sabharwal, by which the concept of post-based roster is introduced. Therefore, in our view, 16.4a and 16.4b form a composite part of the scheme envisaged. Therefore, in our view, articles so together form a part of the same scheme. As stated above, 16.4a, 16.4b, both inspired by observations of the Supreme Court in Indira Sani and RK Sabharwal, they have nexus with Articles 17 and 46 of the Constitution. Therefore, we uphold the classification envisaged by Article 16.4a and 16.4b. The impugned constitutional amendments, therefore, do not obliterate equality. So, Lord, here they've extended that principle of Indira Sani of BCs to SCs and STs. Can I take your lordships to 16.4a and 4b, my lord, just for the sake of reference? Lord, may kindly have the Constitution, my lord. For A reads, my lord. For A, my lord. Nothing in this article shall prevent the state from making any provision for reservation in matters of promotion with consequential seniority to any class or classes of posts and services under the state in favor of scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented in the services under the state. So, my lord, here specifically, the state is endowed with the power
to make reservations in promotion.
To make reservations for scheduled castes and scheduled tribes, which in the opinion of the state are not adequately represented. Not backward classes,
Only
even
SC
within the scheduled caste and scheduled
that too
tribes.
not adequately represented. There is
Yes.
therefore quantifiable data.
Yes. So therefore, my lord, in scheduled caste also, there may be some which are adequately represented, some which may not be totally adequately represented. So they can be carved out under 4A and then, my lord, for consequential seniority under 4B.
Which other judgment are we done now?
Yes, my lord, Nagraj is done, my lord. We can come straight away to Devender, my lord, now, which your lordship was saying is the latter reference order, my lord.
This is Arun Mishra.
Yes, which is 2010. Which page? Page 1400, my lord, PDF
1404,
1404.
2028 SCC page 1.
That's right.
But now you have taken us through the basic judgment. You don't have to go through the reference.
That's
order.
right. I think this discusses everything in detail, my lord. I'll
Yes.
just come to the relevant parts of it.
It basically extracts all the judgments.
My lord, may come straight away to, my lord, page 1416, which is 1420 PDF, my lord.
One four.
1420 PDF, running 1416.
Just below Nagaraj.
The opinion of Justice Arun Mishra, this was a unanimous verdict, my lord. It's authored by him. A bench of 3 judges. May I, my lord?
Bench of 5.
5. This is 5.
Reference by 3,
That's right, my lord. Reference by 3.
decided by 5.
That's right. It's not a simpliciter reference. Your lordship said correctly put it. It gives details, my lord, as to why they feel that Chennaiya needs to be
It
represented.
answers all those 3 questions.
Yes, that's right. That's right.
They made recorded all your arguments here.
Exactly. my lord.
And held in your favor.
That benefit I surely had, my lord. Para 2, they frame the questions, my lord.
See para 35 at page 1458. Before that, it's basically quotations.
Have your lordship seen para 7, my lord, where the submissions are noted and then the conclusions? Or we can come straight away to the findings, my lord.
Yeah, we can go straight to the finding. First sentence of para 35, they formulate the question whether it amounts to an inclusion or exclusion
That's right.
subclassification.
Not- In fact, not a reference is made to Justice Sinha's opinion from Chennaiya in para 20. Page 1431 PDF, my lord. If your lordship could just have that.
Yeah, Mr. Shankaran, you're right. It's para 33 placitum D. They say the preferential treatment would not tantamount to excluding other classes as total deprivation caused to any of the castes in the list of scheduled castes. It is a case of classification to provide benefit to all and to those deprived of the benefit of reservation, being the poorest of the poor. say, raise the question whether the action based on intelligible differentia to trickle down the benefit can be said to be violative of Articles 14 and 16, and whether subclassification can be said to be an act of inclusion or exclusion, particularly when various reports indicate that there is inequality inter, say, various castes included in the list of scheduled castes. They do not constitute homogeneous class, have been relied upon.
In fact, Lord, in this, they opine that Jarnail Singh lays down the fact that creamy layer is applicable to SC/ST in para 27. If your lordships. After discussing Ashok Kumar,
then they say in para 44 again. At page 1462. The caste or group or subgroup continued exactly as before in the list. It is only those persons within that group or subgroup who have come out of the untouchability or backwardness by virtue of belonging to the creamy layer who are excluded from the benefit of reservation. The million-dollar question is how to trickle down the benefit to the bottom rung. Reports indicate that benefit is being usurped by those class who have come up and adequately represented. Clear caste, occupation, poverty are interwoven. State cannot be deprived of the power to take care of the qualitative and quantitative differences between different classes to make ameliorative measures.
para 46 also, your lordship may have, there is a cry.
Yes, para 46 is important.
Para 46, there is a cry and caste struggle within the reserved class as benefit of reservation in services and education is being enjoyed. Who are doing better hereditary occupation? Yes. The scavenger class given the name of Valmikis remains more or less where it was, and so on. Disparity between scheduled castes is writ large from various reports. The sub-classification was made under section 4, subclause 5 of the Punjab Act to ensure that benefit of the reservation percolate down to the deprived section and do not remain on paper, and to provide benefit to all and give them equal treatment, whether it is violative of Article 14. In our opinion, it would be permissible on rational basis to make such subclassification to provide benefit to all to bring equality, and it would not amount to exclusion from the list, as no class oblique caste is deprived of reservation in totality. In case the benefit which is meant for the emancipation of all the castes included in the list of scheduled castes is permitted to be usurped by few castes who are adequately represented, have advanced and belong to the creamy layer, then it would tantamount to creating inequality, whereas in case of hungry, every person is required to be fed and provided bread. The entire basket of fruits cannot be given to the mighty at the cost of the others under the guise of forming a homogeneous class. The Constitution is an effective tool of social reformation. Removal of inequalities intends to wipe off tears from every eye. The social realities cannot be ignored and overlooked, while the Constitution aims at comprehensive removal of disparities. The very purpose of providing reservation is to take care of disparities. The Constitution takes care of inequalities. There are unequals within the list of scheduled castes. Scheduled tribes and socially and educationally backward classes. Various reports indicate that scheduled castes and scheduled tribes do not constitute a homogeneous group. The aspiration of equal treatment of the lowest strata to whom the fruits of reservation have not effectively reached remains a dream. At the same time, various castes by large remain where they were and they remain unequals. Are they destined to carry their backwardness till eternity? Then they answer it in 48 and 49. The state's obligation is to undertake the emancipation of deprived section of community and eradicate inequalities. When the reservation creates inequalities within the reserved class itself, it is required to be taken care of by the state.
Yes, I think we can leave the judgment. Thank you, Mr. Advocate General. I think we are wrapped up now.
Please, Lord, I think that's more or less
Thank you so much, Mr. Advocate.
Grateful.
Mr. Farasat, what ground are you going to cover now?
I have now 3 submissions. I'll just formulate them and then I'll go straight into them also. First, the first submission is that Chennai has certain internal contradictions because it's proceeded on the basis that Article 341 is solely for the purpose of reservations alone.
No, it's for the purposes of this constitution.
That's correct. So, Malaz, the way Chennai proceeds, absolutely, I'm so grateful to Malaz, the Chief Justice. The way Chennai proceeds, it in fact says that.
All right, you can formulate and then.
Yeah, so that's the first formulation.
Yes.
Malaz, the second submission is that Article 342A has now been introduced in the Constitution, and that
Article?
342 capital A has been introduced in the Constitution, and that read with your Lordship's judgment in Jaishi Patil completely negates the fundamental logic of Chennai. And the third submission is that insofar as efficiency in service, that is Article 335 is concerned, that is something when read in the context of Constitution, in fact supports subclassification. It does not negate subclassification because Chennai, because Article 335, the requirement of efficiency in administration of the government, mandates or requires subclassification. Just before I go into each of the points, Malas, there are, if I may submit, there are broadly 2 approaches your lordships have followed. Malas, this is at the risk of slight oversimplification in matters of reservation. Malas, one is, if I may articulate it, the cautious approach, where the court is primarily concerned with preventing misuse of reservation, ensuring that it goes to the right people, ensuring that hopefully in a certain amount of time it comes to an end. Well, the order in reference which the learned Advocate General just read is, in my respectful submission, example of that approach. And Malas, there is another approach, which is the deepening approach, which is, Malas, the court is primarily concerned with how to deepen the impact of reservation to all the groups. And that is the primary concern which the court is really concerned with. Malas, my respectful submission is that the question of subclassification within scheduled castes and scheduled tribes, irrespective of which of the approaches the court takes, leads to the same conclusion.
That is the first approach you say?
Because I said it's a cautious approach, where the court is more concerned with the formal mechanisms of reservation and preventing its misuse.
Yes.
In the second, my lord, the court's emphasis is more on deepening the impact of reservation. If I may say so, my lord, the Chief Justice's judgment in Pavitra is an example of the deepening approach. And my submission is that irrespective of which of those 2 approaches the court takes, both of them lead to the same conclusion. That is, subclassification is not just constitutional, but possibly desirable and necessary. Second, it is clear that the principles which apply in the context of reservation versus non-reservation can be mirrored in the context of subclassification within scheduled castes, no doubt about it. Well, the same principles can be mirrored, like my Lord the Chief Justice pointed out in the morning. However, Malaz, in my submission with one difference, and that is that when we are dealing with scheduled caste, we are dealing with the weak and the weaker. There is no forward group. Plus, that distinction is of some essence. Because this subclassification, either in the way we formulate our submissions or the legislature or the court engages, should not be used to beat the parent category of scheduled class itself. Because that is also essential. So really, we are discussing not a forward, backward, or more forward and backward within backward. We are discussing weak and weaker. So with that distinction, I will just broadly go into my first submission. Your lordships will straight away have Chennaiya para 41. And that is, my lords, internal page 418, volume 5, and running page 798. Volume 5, PDF, page 802. Begins at 801 bottom. Well, this is Justice Hegde speaking for the majority. The conglomeration of castes given in the presidential order, in our opinion, should be considered representing a class as a whole. The contrary of para 41, my lords, 41.
Page 801.
My lords have it. Lord Justice Gawai has it.
Page 801.
That's right. Plus PDF 801.
PDF 801, otherwise it is 797.
That's right. I'm grateful. The conglomeration of castes given in its presidential order, in our opinion, should be considered as representing a class as a whole. The contrary approach of the High Court, in our opinion, was not correct. The very fact that a legal fiction has been created is itself suggestive of the fact that a legislature of a state cannot take any action which would be contrary to or inconsistent therewith. The very idea of placing different castes or tribes or groups or parts thereof in a state as a conglomeration by way of a deeming definition clearly suggests that they are not to be subdivided or subclassified further. If a class within a class of members of the scheduled caste is created, the same would amount to tinkering with the list. Such subclassification would be violative of 14 of the Constitution. It may be true, as has been observed by the High Court, that the caste system has got stuck up in the society, but with a view to do away with the evil effect thereof, a legislation which does not answer the constitutionality cannot be upheld. It is also difficult to agree with the High Court that for the purpose of identifying backwardness, a further inquiry can be made by appointing a commission as to who amongst the members of scheduled caste is more backward. Now, this is important. If benefits of reservation are not percolating to them equitably, measures should be taken to see that they are given such adequate or additional training so as to enable them to compete with the others, but the same would not mean that in the process of rationalizing the reservation to the scheduled caste, the constitutional mandate of 14, 15, and 16 be violated. So, what the court is suggesting, and this becomes more explicit in Justice Sinha's opinion, which I'll just read now, is that you can take other measures for them, but not reservation. That is the suggestion. And that will become explicit. Your lordships will now have para 114, which is at page 819 PDF.
890.
819, my lords. Para 114, it begins under the heading, what is the remedy? So, my lords, after holding it to be unconstitutional,
Page.
PDF page 819. 819. The last page of the judgment.
What is the remedy?
that's right. There is one practical aspect of the matter which may not also be lost sight of. The chart produced before us clearly shows that the members belonging to Reli and Adi Andhra are hardly educated. What are necessary in the situation was to provide to them scholarship, hostel facilities, special coaching, etc., so that they may be brought on the same platform with the members of the other scheduled tribes, namely Madiga and Mala, if not with the OBCs. It is not in dispute that the members belonging to Reli are hardly educated. Only 2% of members of the said community have studied in secondary school. And then there is some discussion, etc. So what the court is suggesting as a remedy is that you give other forms of affirmative action only to the subcategory. That, in my respectful submission, is a contradiction in terms of interpretation of 341 itself. Because 341 is scheduled caste for the purposes of this constitution. It doesn't say for the purposes of reservation alone. So my submission is, in their imagination, the court, the Chinaya court has assumed that 341 is really for reservation. You can do these other things which will not hit 341. But in fact, those very things which the court suggests will equally be hit by the interpretation of 341.
In fact, they are supporting your argument here.
In a way, yes, Manoj. So what I'm really saying is that if what the court suggests is possible.
And identified them and accordingly dealt with it.
Correct. So Manoj,
I accept the position that there are more backward among the backward.
yes, correct. So factually they concede, the court says that factually the problem exists. And it says
But
the
reservation is not the remedy.
reservation is not the constitutional remedy because it's not permissible on account of my interpretation of 341. But at the same time, the court says there is other remedy. What I'm saying is either both remedies are available to me or none are available to me.
They couldn't have said that you take this and not the other.
That's right. And Manoj,
The
that,
purpose of Article 341 cuts across the Constitution.
that's right.
It's not-
And Manoj, that will become evident when your lordship looks at Article 46. Because for the purposes of this constitution, of course, reservation under 15.4 and 16.4 is one aspect. Now just have a look at 46.4. I know your lordships are aware of it, but just for a moment, have a look at it. Promotion of educational and economic interests of scheduled castes, scheduled tribes, and other weaker sections. The state shall promote with special care the educational and economic interests of the weaker sections of the people, and in particular of the scheduled castes and scheduled tribes, and shall protect them from social injustice and all forms of exploitation.
This is actually a postulate that the scheduled castes and scheduled tribes are deemed by the Constitution to be weaker sections.
I'm grateful. Absolutely. And Manoj, this 46 is couched in such broad language that any affirmative action will be covered under this for the scheduled caste and scheduled tribe. Scholarships, the kind of examples the court gives in Chennai will be squarely covered by 46. And if my lord now has 15.4 for a moment, because those measures are in effect protected by 15.4. A government can give scholarship to only a subcategory or a group only upon protection from 15.4. So 46 and 15.4 are really two sides of the same coin.
All right.
So Manoj, that is my submission, and therefore the logic of Chennai, if applied fully, in fact is in my favor. Manoj, I'm grateful to Justice Nath for that. Manoj, my second submission is that there is a new provision introduced in 2018. And Manoj, that is 342A. Your lordships will just have that provision first. It is similar but not identical to 342. And something, that's why your lordships were then required to interpret it in one judgment. (342A) Part 1. The President may, with respect to any state or union territory, and where it is a state, after consultation with the governor thereof by public notification, specify the socially and educationally backward classes in the central list. Plus, this is actually amended. Specify the bracketed portion your lordships will leave and be deemed to be socially and educationally backward in relation to the state or union territory as the case may be. Because initially there was no reference to central list.
Initially, it read the socially and educationally backward classes, which shall, for the purposes of this Constitution.
That's right. So there was no reference to central list in the initial 2018 amendment. But clause 2, Parliament may by law include in or exclude from central list of socially and educationally backward classes specified in a notification issued under clause 1 any socially and educationally backward class, but save as aforesaid, a notification issued under the said clause shall not be varied by any subsequent notification. So Malas, clause 342A as it originally stood, part 1 of it was almost identical to part 1 or clause 1 of 342.
Right.
But insofar as clause 2 was there was the word central list, which is different even as it originally stood from 342. Therefore, the question which arose, Malas, in Jayashree Patil's case is what is the real intent of the original amendment to 2018 amendment? Because the word central list is there. So is it taking away the power of the states to actually
Yes,
identify the OBCs.
yes.
Because Malas, this is a provision which for the first time is introduced in 2018. So the power to identify was all, unlike the SC/STs, the power even to identify was always with the states for OBCs.
Yes.
Now this provision is introduced 342A, and the question was, is that power lost?
The power of the states.
Power of the states to identify.
Yes.
And the court says, yes, it is lost in Jayashree Patil. By reading, the question was whether 2 will control 1, clause 2, central list will control 1, or 1 will control clause 2, really speaking. And the court came to the conclusion that the word central list in 2 will be controlled by 1, and therefore the states have lost the power. So although the word central list is there in 342, in Jayashree Patil, your lordship says, in effect, 342 capital A is identical to 342. That is, from here on, for all purposes, not just central list, it will be only the president and thereafter the parliament which will identify the caste. Because that is the majority in Jayashree Patil. Because there's 2 judges. There are 2 judges dissenting also, but that's the majority, 3:2.
They also then held that till such time as the central government identifies, the state list will continue. So the central government has not so far identified, so the state list continues.
Oh, I see.
As a matter of fact, that also then needs to be looked at again, because the entire federal structure is disturbed because the states don't have any power anymore.
It came in 2021.
So 21 is the
21.
So that's the whole issue.
But the 21 amendment was before Jayashree Patil, right?
No, after. As a response to Jayashree Patil. No, I'm just coming to that.
This is 2018.
Jayashree Patil was which year?
2020. Jayashree Patil is 2020.
This is 21.
Malas, the amendment is a response to Jayashree Patil's finding. I'll place that. I'll place that. Yes. Now, my lords will just first have, now the submission I'm making for the court's consideration is this, that even in Jayashree Patil, where the court interpreted 342A to be identical to 342, even though the word central list were present in the second part, despite that says that for all other purposes, that is subclassification, etc., nothing changes. So here you have now for the SEBCs, a structure like 342, but they are permitted to, the states are permitted to subclassify. Well, that's my submission. I'll just make that good by taking your lordship through the judgment. So now on Jayashree Patil, your lordships will straight away have page 1462 is where it begins. And your lordships will have para 162, which is at PDF 1607.
Further, at page number?
So this is at page number 1607 PDF, 1603 on the right hand side. Parliament through the 102nd Amendment clearly intended that the existing legal regime for identification of communities as SC and ST and for inclusion in the list of SC and STs under Article 341 and 342, which had hitherto existed, ought to be replicated in relation to the identification of SEBCs. To achieve that, Parliament inserted Article 338B, which is a mirror image of Article 338 and 338A. The tasks assigned to the new Commission for Backward Class, which is envisioned as a multi-member commission, are radically different from the duties which were assigned by Parliament to the National Commission for Backward Caste Act. Under Section 9 of the erstwhile NCBC Act, which was repealed just before the commencement of the 102nd Amendment, the NCBC was to examine requests for inclusion of any class of citizens as backward classes in the list, and advice of the Commission was ordinarily binding upon the central government. Section 11 provided for a periodic revision of lists. As noticed by Ashok Bhushan J, Article 338B envisions a larger role for the new commission. This commission not only advises the central government but also the states. It is impossible to read Article 338B in isolation from the pre-existing pari materia provisions. It must be interpreted in the light of the two provisions which had existed all this while. 338.
Justice Bhatt also concurred with Justice Bhushan.
No, Justice Bhushan was in dissent. So he is dissent.
Right, with Justice Nazir.
Yes. So on this point, the majority of this judgment was Justice Bhatt, Justice Nageshwar Rao, and Justice Nazir. And the other two judges are really in a dissent.
On this point.
On this. For this matter, this is the only point in this judgment which my submission is relevant.
Relevant for this.
Yes. Now, those provisions clearly contemplate the same consultative role of the commission, etc. I'm not going to read that. Your lordships will now come to 166.
This can be read. This is very relevant.
I'll read it. My learned friend wants to read. This commission not only advises the central government but also the states. It is impossible to read Article 338B in isolation from the pre-existing pari materia provisions. It must be interpreted in the light of other two provisions which had existed all this while, Article 338 and 338A. Those provisions clearly contemplate the same consultative role with the Commission on Policy Matters of the central government as well as the state government. This is evident from clause 9 of these articles. Thus, the Commission under Article 338B is not only assigned a constitutional role, but is also expected to act as an expert and engage with experts in the determination of the communities. 338B5 uses the term SEBC no less than on 6 occasions. The expression also occurs in Article 338B9. Thus, for the purpose of the Constitution, the Commission newly established under 338B, that is NCBC, shall be the only body to whom both the central government and the state government have to turn in all matters of policy. Necessarily, the question of matters of policy would also include identification of caste or communities at backward classes. Now, my lords will have 166. And I'll just read the first part, my lord. I don't want to trouble your lordships with too many paras, and I'll just formulate the point. Given the weight of such precedents, which to this court, giving full effect to the newly added provision by adopting the literal meaning in the definition set out in the Constitution, as well as in the amendments to the definition clause, and all of which was noticed the changes brought about through amendments and gave them plain effect, it is difficult to accept that the power of amendment of the Constitution, in accordance with the special procedure set out in 368, was used to bring about cosmetic changes conferring constitutional status. So, there were two arguments. One argument was that this 342A, if I may use the word slightly funnily worded in terms of in a difference from 342, was only to confer a constitutional status on the status quo which was legally already present.
Right.
And the other argument was that no, this actually brings it in line with 342, states lose the power to identify. The court says it is not cosmetic, it is substantive, and the states lose the power to identify. Now, despite that, what the courts hold is what I am canvassing to the court, my lords. Your lordships will have para 168. And below plus item E. Yet one must be mindful of a crucial fact, which is that the task for making special provisions under Article 15 and for making reservations under Article 64 extends to the states. The power exercised by the President in relation to every state vis-a-vis SC/ST has been smooth, and by all accounts there has been no resentment or friction. Once the community or the caste concerned is reflected in the list of one or the other state union territory, the extent of benefits to be provided to members of such community is a matter that lies entirely in the state's domain. So identification the President does exclusively and the Parliament, but the nature of benefits will be rolled out is in that state's exclusive domain. Now my lords will have para 182. It is at my lords page 1616 PDF. This court is also of the opinion that the change brought about by the 102nd Amendment, especially Article 342A, is only with respect to the process of identification of SEBCs and their list. That is the real meaning of 342 as well. Necessarily, the power to frame policies and legislations with regard to all other matters, that is welfare schemes for SEBCs, setting up of institutions, grants, scholarship, extent of reservation, and special provisions under 15.4, 15.5, and 16.4 are entirely with the state government in relation to its institutions and its public services, including services under the agencies and corporations and companies controlled by the state government. In other words, the extent of reservation, the kind of benefits, the quantum of scholarship, the number of schools which are to be specially provided under 15.4 or any other beneficial or welfare scheme which is conceivable under 15.4 can all be achieved by the state through its legislative and executive powers. These powers would include making suggestions and collecting data, if necessary, through statutory commissions for making recommendations towards inclusion and exclusion of caste and communities. So, Malas, that's the second part on even on inclusion and exclusion I can recommend. But once included or excluded, with that category, what is to be done? The entire gamut of things which can be done is still with the state exclusively. So, Malas, this is Chennaiya goes this way, Malas. This judgment, in my respectful submission, goes the opposite way. It identifies that there are two different things, which is the submission we are trying to make to the court. Now, Malas, finally, your lordships will have para 194.5.5. That is at page 1619.
PDF 1623.
And PDF page 1623. Plus 194.5.5. The state's power to make reservations in favor of particular communities or castes, the quantum of reservation, the nature of benefit, and the kind of reservations, and all other matters falling within the ambit of 15x16, except with respect to identification of SEBCs, remains undisturbed. Remains undisturbed, except identification. Plus, what is the sequitur of this? In SEBCs, Malas, there is subclassification already. Your lordships have seen Indra Sani.
Yes.
Now, here you have a provision which has been read by this court to be identical to 341. And except identification, everything else is left undisturbed. Therefore, Malas, that subclassification power also has been left undisturbed. Now, Malas, what does the amendment do? I'll just conclude this point with that amendment. The amendment came as a response to this judgment, Malas. And that is clause 3. Your lordships will have clause 3. Notwithstanding anything contained in clauses 1 and 2, every state or union territory may by law prepare and maintain for its own purpose a list of socially and educationally backward classes, entries in which may be different from central list. Whereas this restores the power to identify to the state, clause 3. I'll read it again. Notwithstanding anything contained in clause 1 and 2, every state or UT may by law prepare and maintain for its own purpose a list of SEBCs. So this restores the power to identify, which clause 1 and 2 as interpreted by Jayashree Patil did not provide.
This is brought on 15th of September 21.
Correct. But Malas, my submission is this.
The same amendment also amended clause 1
by bringing the central list.
That's right. Also, that's right. I'm grateful, Malas. That was brought in as well.
Specify the socially and educationally backward classes in the central list, which for the purpose of the central government. Those words came in.
So that's true, Malas. So it restores that position. But so what it does, it restores the position vis-a-vis OBCs pre the amendment and pre Jayashree Patil. That's what it does. But my submission is when the court took it as equal to 342, That is what Justice Patil is prior to the amendment. Even at that stage, the court says everything else.
Else is left to the
That's
state.
right. And that is in contradistinction and complete contrast to the approach Chennai has taken.
Right.
That's the second submission. My third and final submission.
Of course, both are judgments of 5 judges.
I will be, and since your lordships are in 7, we will commend the approach of this judgment to your lordships as opposed to Chennai. The third submission is that insofar as Article 335 is concerned, normally it is seen, although some judgments of your lordships in recent times have undone that it is a restriction on the principle of reservation. I'll just read 335. Claims of scheduled caste and scheduled tribes to services and post. The claims of the members of the scheduled caste and the scheduled tribes shall be taken into consideration consistently with the maintenance of efficiency of administration in making appointments in the union or state. Consistent with maintenance of efficiency in administration. In my respectful submission, this provision actually is not a provision which is a limiting principle of reservation, certainly not in government service. And I'll try to make it good. It is in fact an enhancing principle for reservation and subcategorization both.
I think I've dealt with this.
In Pavitra, I'll place those paras. I'll place. Your lordships have dealt with it directly in Pavitra. But before I go to Pavitra, just one submission. What is this is about efficiency is contextual.
Yes.
Something which may be efficient in one context will cease to be efficient in another context. Just one example.
It depends on how you define efficiency. If you define efficiency in an inclusive sense,
yes,
by the inclusion of people who have hitherto been excluded from governance,
yes,
then it promotes efficiency. Also, putting people from the marginalized communities in important positions of responsibility itself is receptive to the needs of those communities and to the need for inclusion as a social doctrine. And therefore, it's not really something which detracts from efficiency.
Absolutely. And in addition,
because the postulate of the Constitution is not that people who belong to the marginalized groups are inefficient and those who belong to the other groups are efficient. And therefore, having more of the reserved categories will detract from efficiencies. To the contrary.
Exactly. So, that's there. And in addition, this is
efficiency. It is consistent with the need to maintain efficiency in administration.
Yes. And efficiency in government administration is what is government administration? Government, what is government? What is government's business is the people. Government's business is the people. So, when we are talking about efficiency in government administration, diversity by itself promotes efficiency. That's my submission for the court's consideration. Efficiency in government administration will necessarily necessitate existence of diversity. Just example, we came across example. In Norway, they recently took a child of an Indian couple because the children were being fed by the hands, through hands by the parents. That is basically, they don't have the understanding, diverse enough administration to understand this is a cultural but hygienic practice. They assume that just because you are using hands, they put the child in foster care. So, efficiency in administration will require a certain amount of diversity because otherwise you will have disastrous consequences of this kind of example. There can be many other examples given, even in our context. So, diversity is essential component of efficiency, especially in government administration, because you're dealing with a diverse public. You're not dealing with just a section. You're not government of A or B. You're government of everybody.
All right.
And I'll just place the paras in Pavitra.
Where is Pavitra?
Volume 5A.
25. Page?
It begins, your lordship will have page 111 PDF, page 111 PDF, para 124. substantive, para 124.
One second, page, para, page,
Page 111 PDF.
yes.
The substantive part of 335 contains a mandate, a requirement to take into consideration the claim of SCs and STs in making appointments to services and posts in connection with the affairs of the union or of a state. Consideration is much broader in its ambit than reservation. The consideration of their claims to appointment is to be in a manner consistent with maintaining the efficiency of administration. The proviso specifically protects provisions in favor of SC/ST for relaxing qualifying in any examination, lowering the standard, or reservation in a matter of promotion. Reservation is encompassed within the special provision, but the universe of the latter is wider. Now, I just have 126. The lordships have written a lot of paras. I'll just focus on the ones which assist us the most. Para 126. The Constitution does not define what the framers meant by the phrase efficiency of administration. Article 335 cannot be construed on the basis of a stereotypical assumption that roster point promos drawn from the SC/STs are not efficient or that efficiency is reduced by appointing them. This is stereotypical because it masks deep-rooted social prejudice. The benchmark for the efficiency of administration is not some disembodied abstract ideal measured by the performance of a qualified open category candidate. Efficiency of administration in the affairs of the union or of a state must be defined in an inclusive sense where diverse segments of a society find representation as a true aspiration of governance by and for the people. If, as we hold, the Constitution mandates realization of substantive equality in the engagement of the fundamental rights with the directive principles, inclusions together with the recognition of plurality and diversity of the nation constitutes a valid constitutional basis for defining efficiency. Our benchmarks will define our outcomes. If this benchmark of efficiency is grounded in exclusion, it will produce a pattern of governance which is skewed against the marginalized. If this benchmark of efficiency is grounded in equal access, our outcomes will reflect the commitment of Constitution to produce a just social order. Otherwise, our past will haunt the inability of a society to move away from being deeply unequal to one which is founded on liberty and fraternity. Hence, while interpreting 335, it is necessary to liberate the concept of efficiency from a one-sided approach, which ignores the need for the positive effects of the inclusion of diverse segments of society on the efficiency of administration of the union or of a state. Establishing the position of SCs and STs as worthy participants in affairs of governance is intrinsic to an equal citizenship. Equal citizenship recognizes governance which is inclusive, but also ensures that these segments of our society, which have suffered in history, prejudice, etc., are the real voice in governance. Since inclusion is inseparable from a well-governed society, there in our no antithesis between maintaining of efficiency and considering the claims of SC/ST. This formulation, I respectfully submit, should be adopted by your lordships in the 7-judge combination, so that 335 is not seen as a limiting principle to reservation, but as a principle to expand, just like firstly 16.4 was seen as an exception to 16.1 in the initial jurisprudence of this court, and then your lordships have held that 16.4 is actually a facet of 16.1. Similarly, this is also in fact a facet, and therefore insofar as Chinaya, which are two places.
Indira Sawhney also rejects the argument that reservation is anti-meritorious.
That's right. That's right. Merit is what they call in one of these books nurtured talent. If somebody doesn't get to, and something called natural talent.
I think I've also considered that here.
Yes.
And how benchmarks and,
Yes, your lordships have given a very detailed this thing. I'm not reading all of it. But the principle really is that 335 is not, efficiency in governance is not about efficiency for a particular group or defined in a void. It's not rocket science, particularly in government. When you're dealing with people, efficiency has to mean how does a government really deal with all the people? And if I may submit, we really don't know what real efficiency is, because real equality really has not arrived in our government. We will see the true meaning of 335 when we have a substantive equality, and then we'll see what real efficiency is. That's the true meaning of 335. So insofar as Chinaya in some paragraph says that this subclassification will also be contrary to the principle of efficiency. It's neither contrary to principle of efficiency for normal classification or for subclassification. So that's my third submission.
Thank you, Mr.
Yes. There is, I will not quote it, but we used to read in our NCRT books, Gandhiji's talisman, that whatever you do, you must think of the weakest person. And does that help that weakest person? And all your doubts will disappear. Well, this is one of those instances where what the state is doing is actually helping the weakest person. I'm grateful.
Thank you, Mr. Agarwal. Mr. Sibbal? We start tomorrow morning. We're almost on the envelope. 4 o'clock.
All clocks put to this side of the lawyers. I have got the time 2 minutes of. And see it.
Yes.
Say to the quality minutes, one on this side.
What we'll do is now, we've substantially covered a lot of ground. We've covered a lot of substantial ground. We'll conclude the submissions of this side by lunchtime tomorrow.
Yeah.
So that then we can ask the others to, the other side to argue. So if, we'd like to wrap up tomorrow because, you know, I mean, we'll see what they have to say after this. So we'll conclude the.
Yes, I think so. Not an issue.
So just as you leave, maybe the others who have to follow can, between yourselves, ration the time for the people who have appeared.
Not an issue. We'll organize that. Great.